It's a lecture entitled We Cannot Say We with Hans Lindahl, Emeritus Professor of Philosophy of Law in Tilburg and holding a chair of Global Law at Queen Mary University of London. Speaking today on the representational role of the judiciary and of climate litigation in democracy. I think you'll speak for around 45 minutes, and that gives us another 45 minutes for questions and discussion. So I would say take it away.
Great. So thanks very much to Christina and to Clara for this invitation. We met at my colleague Phil Payman's inaugural workshop a couple of months back, and you presented the ideas of a paper that you afterwards circulated or passed on to me. And I was so irritated by the anti-democratic character of the steps which are being taken to muzzle public litigation in climate that I think I showed some of my anger, and so I was invited to present some of that anger with you guys today. So yes, I've been working well since 1850, I guess. With my whole research actually comes down to one word. I've been researching one word for 30 years. And that's the word we. When Mr. Wilder says Henk and Ingrid, there is a specific reference to what the we holds. When we speak about we Europeans and think of a common market, or when we're prepared to let people drown crossing the ocean, well, the Mediterranean Sea, to come here, there's a specific understanding of we. In fact, when we use the word we, without which we cannot actually begin to make sense of a legal word, there's a process going on of inclusion and exclusion, at its core, the result of the very structure of representation. And so what I want to discuss with you today is basically the notion of representation. What I will be doing is actually giving you a lecture. What I'm going to present to you today is very much a fragment of what I've been doing in my course in legal philosophy for law students at Tilburg University. I've also circulated a paper, for those of you who might be interested, which offers a more technical account of what I want to say today. I will not be using that paper as a reference what I will be doing. I will be much more focusing on the concept of representation, of fleshing it out, and then zooming in indeed on the problem of climate litigation. And so I've changed the title of the subtitle a bit. I had begun by litigation and representation. I thought it's better to begin with representation, because litigation, and that will be one of my arguments, is a form of political representation. And I'm also referring to the emergence of plural subjects. If I hadn't put that in parentheses more than human, it would be basically our mainstream understanding of what collective agency is, the we of a democracy as we've understood it in modernity. But by introducing more than human, what I want to add is the suggestion that structures of representation help us to understand something like the emergence of more than human plural subjects through climate litigation. So that's what I want to present to you today. And once again, many thanks for the invitation, and I look forward to the discussion. So I'd like to split my presentation today into 7 parts. Quickly begin with litigation and climate litigation, or if you wish, public interest litigation as being under fire, but in particular climate litigation. And I will want there to explain what are the presuppositions for the critique which has been issued of climate litigation, both in the doctrine and in politics. Then I will move into the concept of representation itself. What I will want to do is draw a distinction between what might be called representationalism. That's a certain understanding of representation which is mainstream and which I think is crap. And then I'm going to propose an alternative reading, which I think actually gets it right. Allow me for saying that this is my account of it, but then I must confess that modesty has never been one of my character faults. The third point will be trying to make sense, therefore. I'll argue that subjects can only be represented, and that therefore, in the very process of representing unity, you create also plurality. And so what's at stake in representation and in democracy is plural subjectivity. I will then discuss its scope. Then I will try to argue that representation is actually a responsive process. And I will try to show how that might help in making sense of litigation, public interest litigation and climate litigation in particular, and how that explains the emergence of more than human plural subjects through climate litigation. And then I will share with you some of my ideas about possibilities and limitations of climate litigation. One of the advantages of being an emeritus is that I don't have to teach anymore. I shouldn't be saying this, of course, and that I don't have to engage with university politics, which in times of the budgetary cuts that we're facing, of course, is extraordinarily fraught. And because I only have this and a following incarnation, I've limited myself to 2 books, which I still want to write before perhaps stopping. And I'll share you in that seventh point some of the ideas of where I think one can take climate litigation and what are also its limitations. So obviously climate litigation is under fire. And I think the paper which Christina, which Clara and August is August here with us today? No. Okay, well, the paper that Christina passed on to me, Democratie en vertegenwoordiging van het algemeen belang, de kabinetsplannen voor ontvankelijkheid van NGO's in het licht van klimaatsignorerinnen, in a Swiss case, which went on to the court, is I think very topical in terms of the kinds of issues that climate litigation confronts. I didn't, when preparing these slides, engage actually in any detail with your paper, but I thought we might save that for the discussion. That might make it more fun, more interesting. But of course, we have the Urgenda case, we have the Shell case, the Greenpeace case more recently. And a lot of it from both the doctrine and from politics has been a huge outcry in terms of its the judiciary stepping outside of its role within a democracy and breaching the fundamental principle of the division of powers within a democratic government. And so the attempt has been made to delegitimate these and other cases, and not only in the Netherlands, but elsewhere also, in terms of the assumption that the judiciary basically has to leave these kinds of political issues to Parliament or to Congress, to another power in any case, and not take the initiative to be transformative in the way that these cases at least potentially are on a legal level. And the basic argument there is the tyranny of the judiciary. Here you have a branch of power which is not elected, which is engaging in acts which should be reserved, given the gravity of the transformative effects of those rulings, at least in principle, to another power. That's one way of looking, one way under which climate litigation, and perhaps even more generally public interest litigation, is increasingly coming under fire. Look at what's happening in the US nowadays, and not merely only in terms of climate litigation, but also what has been at stake is the very notion of the representativity of public interest litigation. That is to say that those interest groups which engage in public or litigation, whether in the Urgenda, whether in Shell, whether in Greenpeace or whatever, are themselves in fact not representative organs, and that they are therefore in fact expressing a minority view, and that to the extent that courts will actually play into this and declare the as one would put it in Dutch, ontvankelijkheid, will be prepared to take on the cases, that the judges are playing into the tyranny of the minority. So it's a double whammy against climate litigation: the tyranny of the judiciary, the tyranny of a minority. And the arguments for these 2 critiques are arguments from democracy and from the rule of law, rechtsstaat. In terms of democracy, first and foremost, of course, if democracy is collective self-legislation, then the idea is, of course, that it's the people who have to basically enact the law, certainly the Constitution, but also statutory law to the extent that statutory law engages in these kinds of transformative lawmaking, this kind of transformative lawmaking, which we see in cases such as where the rulings of Urgenda and Shell and so forth. So it's an argument about the very notion of democracy as collective self-legislation, that is to say, use Abraham Lincoln's formulation, government by the people and for the people. But of course, to the extent that, at least in our larger communities, we have relinquished the statutory powers and constitution-making powers to a parliament, then we're prepared to accept that there is a representational form of collective self-legislation. So it's the people through their representatives who enact legislation. But we say, well, of course, at the end of the day, if it is a representative democracy, that means in the case of the Netherlands, for example, that we have parliament. In the case of the United States or other presidential systems, it's Congress or whatever. And the idea there is, of course, that you would restrain, you would want to make sure that it's Parliament or Congress working together with the president or with the government to enact legislation if it is to be democratic. And if you were to nonetheless want to force things because, say, there's a blockage within Parliament in terms of taking the kinds of steps which Urgenda or Shell suggest would be necessary if we're going to deal with future generations, then if you're going to engage in collective self-legislation, you should go for a referendum or a plebiscite, something like that, so that the people themselves directly should be able to decide which way we go with these very thorny issues. So that's, in a sort of Mickey Mouse version, the argument from democracy. And it fits seamlessly into the argument from the rule of law. And there, of course, you have the trias politica, you have the distribution of powers. And if I put it in a very crude way, the idea is that the distribution of powers entails that it's the representative body, which is basically, well, in Article 50 of the Dutch Constitution, it's de Staten-Generaal vertegenwoordigen het gehele Nederlandse volk. I'll come back to that in a minute. And working to the wetgever, therefore working with the government, they are entitled to and competent to issue general norms. And it's a task of the judiciary and the executive. The executive has a certain hybrid role here to apply the general rules which are issued by the legislature. So that's one argument. The first argument from the rule of law. You see here an usurpation of a democratic power which is not its own by the judiciary. And to the extent that the judiciary is doing this, then it's infringing also the principle of legal certainty. I think there's no more cardinal sin than that you could say about a judiciary, that they are, in fact, they are the guarantors, the Buddha of legal certainty, and here they are raping it. And so these are, I think, basically, as I say, in a very Mickey Mouse version, very compact, the kinds of arguments which are being raised against climate litigation, both against the judiciary and against groups, of interest groups that are engaging in climate litigation or otherwise in public litigation. Now, what are the presuppositions which underpin these critiques? The critique from democracy and the objection from the rule of law. Well, the first one is that where you would actually have to look for in terms of making sense of where political representation should take place in a democracy is in the enactment of statutes and constitution making. And I use here the notion of statute in its material sense. So there might be forms of executive acts which are statutory in a material sense, but by and large, we would expect that it is that the statutes and constitution making are the forms of political representation. Everything else, and that means judicial rulings, that means also administrative acts that are sort of applying these general rules down to an individualized act, in Dutch beschikking. These are not acts of political representation. And because, therefore, judges are not political representatives, and they're not political representatives quite simply because they are not elected, at least in principle not elected, at least in the Netherlands they're not elected. They are appointed, but they are not elected, and in the case of the Netherlands it's co-optation, whatever. But because they are not elected by the people through secret and general elections, then they are not in principle allowed to engage in acts of political representation. And because they are not an elected organ, then what we actually mean implicitly saying is that, well, the people that we have in mind when we say that it's the people who has to authorize political representatives is what we would call the constituency, in Dutch, the achterban. Unless you have the people as a constituency authorizing you to act as a political representative, you are not entitled to enact statutes or constitution. And therefore, the most general, perhaps, presupposition here, on the basis of these preliminary 4 points, is that democratic politics will oscillate between, well, in the course of elections, or in referenda, or in plebiscites, or whatever, moments in which the people, as a constituency, is actually present in the political arena. And then because we cannot all of us sit in the Malieveld and actually engage day in, day out in everyday politics, then the people that have been present in elections, or referenda, withdraws. We go back home and do our stuff, our things. And then at that point, representation takes over. So you oscillate between these two moments of presence and representation. And therefore, the idea, which is inveterate in political and legal theory, is that we have two forms of democracy: representative democracy and direct democracy. We have direct democracy when the people itself is present on the political arena. We would not typically say that elections are a form of direct democracy, but they are direct in the sense that the people is present. And we would say that there is the direct democracy in citizen participation, participatory democracy, etc. Think of referenda, think of plebiscites, but you can think of all kinds of other ways in which the people itself is present in politics rather than represented. Now, my argument is that all of this is bullshit. All of it. And so what I'm going to do is offer an alternative reading. So let's get started with the law, the constitutions. Article 50 of the Dutch Constitution. Parliament represents the entire Dutch people. Article 20, Section 2 of the German Basic Law. All state authority emanates from the people. It is exercised by the people by way of, elections, Abstimmungen, you might want to call that referenda, plebiscites, and by way of specialized organs of legislation, of the executive power, and of the judiciary power. Now, the way this is typically read ties directly into what I've just said. Basically, the idea there is that when we speak about the people in Article 50 of the Dutch Constitution, de Staten-Generaal vertegenwoordigen het gehele Nederlandse volk. Het gehele Nederlandse volk that we have in mind is basically, that part of the, to the extent that it's the entire Dutch people, it's the 18 million Dutch citizens that we have, of which, say, 12 million are entitled to vote. So the idea there is that when a parliament represents the entire Dutch people, the standard reading of this is that it's the constituency, the 18 million people of whom, citizens of whom, say, 12 million are entitled to vote. If you look at how the Bundesverfassungsgericht has interpreted Article 20, Section 2 of the Grundgesetz, it's basically the same thing. Alle staatsgewalt geht vom Volke aus. That's a principle of popular sovereignty, of collective self-legislation, if you wish. And the idea is there that basically it's the people that is the ultimate highest power from which all legitimate lawmaking must emanate, and that therefore, to the extent that law, which is issued by the Bundestag or by the executive or by the judiciary, is issued in namen des Volkes, In contrast to Dutch law, all German rulings begin with in namen des Volkes. Well, to the extent that all rulings can be said to go back and sort of in a chain of legitimation to the people, and ultimately to the people as they have manifested themselves through elections, to that extent, law is legitimate. It's democratically legitimate. Now, this is what I want to call representationalism or presentationalism, if you wish. And what I mean to say by that is the assumption that when we are speaking about the people who rules, the sovereign, what we have in mind is the people that is present at sort of certain moments within the political career of a community, whether through the form of elections, referenda, plebiscites, and so forth. And I think that that is an extraordinarily widespread interpretation of what democratic politics is about. It also means, of course, that in a certain sense, representation is a second best solution. So ideally, of course, we would want to have ourselves be the individuals, the citizens who decide for ourselves what law is about. There's, of course, a standard claim and critique of populism. The kloof tussen Den Haag and the burger. To say that there is a gap that emerges in the whole process of trying to put together within a parliamentary system a coalition agreement, which ends up being something quite different to what you voted for when you voted for whatever party you had voted for. But that supposes, therefore, that that gap that there is between representation and presence could be avoided if our collectives in some way were able to get rid of that moment of representation and have the people themselves decide. Then we get the pictures of the Swiss cantons, where all of them are crowded together in the local square and taking decisions about their own capital. So this is the target of my critique. Now, take a look once again here at Article 50 and compare it to Article 22. If you look at Article 22 of the German Grundgesetz, you see that the word people comes two different in each one of the sentences. So the two uses of the word people, whereas if you look at Article 50, you only see it coming once. But actually the two say exactly the same thing. Why? Well, look at the German Constitution. Alle Staatsgewalt geht vom Volke aus. Well, what is referred to here as the people in the first sentence is the people actually as a unity, as a we. And if you look at what it says in the second sentence, then basically it's already pointing through elections and through Abstimmungen, an electoral process, and what's at stake there is plurality. Claude Lefort, a famous French political philosopher, says that one of the fascinating things about democracy is that during elections, that sort of illusion and the fiction of we being one dissolves into literally becoming fragmented into 18 million people, of which 12 million are allowed to vote, and that therefore that unity is, as it were, precisely dissolved into a numerical plurality of individuals, and that you actually have to add up votes to determine what a majority will look like. So you would say, well, in the case of the German basic law, they have this very clearly in mind. But what's fascinating about Article 50 of the Dutch Constitution is a certain ambiguity in the notion of het gehele. I'm not Dutch by origin. No one's perfect. But it took me a while to realize that that notion of het gehele has an ambiguity. You can read it as het Nederlandse volk als geheel, and as a whole, as a unity. Or you can read it as the entire, as they're saying, the summation of an X antal individuals who happen to be Dutch. And so if you have in mind that ambiguity in the notion of het gehele Nederlandse volk, then you see that actually, and that will be my argument I'll present just in a bit, that you actually need both senses of peoplehood in the notion of democratic representation. People as unity, and people as plurality. So we as one, we as many. And what's fascinating here is that one pronoun we. So I would say that when we speak about we as one, what we have at stake here is, of course, the notion of unity. But in terms of theories of collective action, it's we together. And when we speak about we as many, therefore as plurality, we have in mind it we each. And I'm drawing on the distinction between we together and we each from a well-known theorist, philosopher of collective action called Margaret Gilbert. Let me give you an example of what the distinction actually means. So imagine that after this lecture and after the talk, we had agreed that we would all go down somewhere into close to Central Station, where I can take my train back to Deventer, and that we're going to have dinner together. And so we step out here. We'll go to the metro here and wherever close by, and the metro arrives. And it happens that I'm a hillbilly. I've spent 20 years of my life in Tilburg. I'd never seen a metro before. I'd had to go down for that. And so I'm, astonished by this. Wow. And I haven't noticed that the doors of the metro are just about to close. All of you who are nasty people have noticed that I'm distracted. And I'm just waiting to see if I will actually turn around and jump into the metro before it leaves. And I haven't. And so the door's closed and I turn around, spin around on my heels to look, and all of you wave at me. Bye, Mr. Lindahl. Well, of course, I could be very angry and give you guys a middle finger, but strictly speaking, you don't have any obligation with me because, you would have an obligation with me because we're in this together. And so if what we're doing is in forms of collective action, actually going someplace to have dinner together, then actually in a certain sense it's our proto-obligation to help each other out such that we can do that which we have agreed to do. Now that's already the basic presupposition of what we might want to call legal rights and obligations. Legal rights and obligations emerge with the emergence of the first person plural perspective, we together. But imagine that very same situation where after the talk and the discussion, whatever, each one of us, we disband, each one of us is going to go home, and several of us are milling around on that very same metro station, and the same thing happens, and I spin around. I might be annoyed that people are nasty, but you don't have an obligation, me, to tell me that. We each are going home. There's no collective action. And so when the American Constitution begins with we the people, the argument is that we the people there means we together, not we each. It's the people as a whole, as a unity, which is claimed by the people who enacted the Constitution and earlier individuals who declared the independence. That reference to a we is a reference to unity, to we together, not merely to we each. But notice how plurality comes into the picture in the very act saying we together. In the case of the US, we the people was basically white, well-endowed male citizens. Women were not part of it. Indigenous peoples were not part of it. Blacks were not part of it. And my argument would be that actually this is part of the very structure of representation. And so what I will say is that democracy, that's why democracy needs both senses of peoplehood. We together and we each. Come back to that. And so what I'm arguing for is that what is represented is the people, but not in terms of the constituency. There's the constituencies, or you might want to say, for example, that the VVD has their achterban, their constituency, and what the VVD is trying to do, or PVV, or any one of the parties, or the Democrats or the Republicans, is trying to articulate what their constituency thinks about certain issues in the country. But even there, the constituency of the VVD or PVV or whatever, they are having to articulate what they think these, whatever, how many thousands or more people are involved, actually what joins them together. So even when the VVD claims to speak on behalf of their constituency, they are representing their constituency as a unity. They're saying what it is that they hold in common. And unless representation were about what we hold in common, then we could not make any sense of the claim in democracy that the law has to be general. That it is, in other words, the articulation of the general or common interest. Because when we speak about the common interest, that's the way in which we try to articulate what it is that we hold in common, that is to say, what we share as a unity. But of course, the whole point, and that's why what is represented is unity, not plurality, is that we can only make sense of a minority and a majority as part of a unity. Without unity, it makes no sense to speak about minority and majority. And that's why a simply formal understanding of democratic decision-making that would simply make sure that what we're doing is making things public in terms of statutory projects, that voting takes place in the proper way, etc. All of that, in terms of trying to articulate what is a majority position on lawmaking, on the generality of the law, presupposes a prior enclosure that determines who is the we, on whose behalf we're speaking. But because there always has to be a and saying that there was place for Jewish Dutch, there was place for Dutch Muslims, etc. And Wilders immediately came back out and said, well, we are proud of our tradition, our culture, and so forth. Even the king, who is supposed to stay out of politics, could not say that he's acting on behalf of the unity of who we are, without in fact already giving it some kind of a content, and therefore both including and excluding, such that some will take issue with who is excluded and some with who is included. So representation is an act of inclusion and exclusion, always. And that's another way of saying that we represent ourselves, or actually someone claims to represent us as this. We are a people that believes in the notion of a welfare state, a social democracy. We are a people that believes in tolerance. We are a people that believes in this or that. But in the very process of trying to articulate who we are, because if you don't at least say minimally who we are, how can you actually begin to have collective action? We have to have a sense of who we are to be able to act collectively. In that very process, you are excluding that when you're saying we are this. But of course, that also means that we are more and other than our self-representations. In the very process of saying we are this, there will probably, and therefore an act of integration, of bringing into the fold of unity a number of individuals who happen to meet that criteria. Maybe many of those individuals happen to think, no, that's actually not who I understand myself as being about as an individual or as a member of this collective. And the paper which I circulated is, I think, an extreme case of that situation of representation. I assume that you haven't read the paper. And so it was a case of the McMahon government in Australia back in the 70s, which was very conservative and which wanted to integrate Aboriginals into the Australian settler culture. And so basically what the McMahon government did was say, look, sure, you can have land rights, but to get them, you have to basically integrate. And that means get to know the settler culture, you need to learn the language, etc. And many of the Aboriginals took very strong issue with this. And a group of 5 Aboriginal activists said, well, if we're going to be treated like aliens within our own country, then like all alien nations, we need an embassy. So that they pitched a tent embassy on the old lawns of Canberra, on the lawns of old Parliament House in Canberra. And so what they were saying is, basically, they don't want to have rights. They're not claiming the right to have rights. They're claiming the right to not have rights. And so much of our liberal political democratic theory is about being more inclusive. But what happens when inclusion is a problem than the solution? And so what you see happening in representation is the ambiguity. No collective without representation, but at the same time, representation always undermines the possibility of collectivity. So in a certain sense, if I can press the point, representation is indispensable, necessary for collectivity, and it is also what renders collectivity in the strong sense impossible. Which is why representation involves both we each and we together. So representation is also depresentation. We are more than what it is claimed that we are. And it is also misrepresentation. We're something other than what is said that we are. Which means that what representation does is make a collectivity possible, but it also means that it's always a question about, well, is this actually who we are? And are we actually at all a collective? Now, what this means in terms of the concept of representation is that the people as a unity is always absent. So look once again at Article 20. Alle Staatsgewalt geht vom Volke aus. Now, in this first sentence, against the readings of the Bundesverfassungsgericht, what I would argue is that what in this sentence you see is precisely the people as unity. And because it is represented through the people as the electorate and through the three powers of government, then because these different powers have to represent it, it's always absent. What does it mean that it's absent? Well, imagine that we were purists and we are a party that really wants to represent the Dutch people in terms of Article 50. And that we do not want to distort the representational function of Article 50. So we set up, we are that party. And we decide that we're really going to be even better than NSA. We're going to be the party that really represents the general interest of the Netherlands. We call ourselves the ABN, which has nothing to do with the bank, Algemeen Belang Nederland. So then the next step is we have to put together a program, political program. Well, what could our political program consist of? One sentence. We stand for the general interest of the Netherlands. Period. Because if you go one step further, we're for lower taxes, we're for this, we're for that. You're already defining who is a we, you're including, and you're excluding. And so when Article 22 says, alle Staatsgewalt geht vom Volke aus, it's referring to a people that is nowhere. It is, strictly speaking, not empirically either visible or present. It is, in a certain sense, what Hans Blumenberg, a famous German philosopher, said about human being. You know what he says? What we're always busy doing is trying to reduce the absolutism of reality. And in a certain sense, what this article is doing is reducing the absolutism of someone like Trump. Because Trump basically is trying to be absolute in the sense that he knows what the people want. Make America great means basically he has intimate knowledge of what it is that America is about, and that it has now degenerated. He's going to recover that. And so what you get is a collapse of the people into the representative. Claims to know what the people really want. And so what Article 22 of the German Basic Law does is precisely to separate the people as always absent. That is to say, sure, we strive for unity, but we never get it. And never getting it is part of what democracy is actually about. Building in a sense of suspicion about any claim to unity, which is raised on behalf of the people. And that same thing is actually what happens in Article 50 of the Dutch Constitution, even if you only have one use of the word people. It's both people as unity, which is always absent, never present, and the people as present by way of elections, referenda, etc. And so this means that we cannot say we. Even if 18 million people were to somehow be packed into the Malieveld in The Hague, and all at exactly the same moment were to say we, that could not be unity. And why not? Well, for example, think of issues of collective responsibility. How would it be possible for us today in the Netherlands to even contemplate the possibility of reparations to having made slaves of so many people in Suriname? All of the people that participated in that in those days in the Netherlands have died. How could we possibly, if the people were a number of individuals who were citizens then or now, how could we still today be held responsible for that? The only possible understanding is if what is represented is precisely a unity that is understood as being a unity across time, but that cannot be collapsed into a certain number or of individuals that are taken to be the constituency at a given point. And so we cannot say we. Someone has to act and say we on behalf of the we. Which means that elections and referenda and plebiscites are representational acts. What do you do in an election? Well, basically you vote for a party. And what are you voting for? Well, you can vote for, of course, the individuals, but basically you're voting for that individual because you think that that person is the kind of a person that this country needs. That is to say, that is a person who can articulate who we are in a way that you can identify with. You're also voting, if you take the trouble, for a political program. In both cases, the individual and that political program are themselves representations, answers to the question who we are, with which you can identify. And so in casting your vote, you are participating in representation. And therefore that means that direct democracy is itself, in fact, representative democracy. We can, of course, institutionally distinguish between referenda and elections, but not in terms of their essential function. Their essential function is to articulate what we hold in common, and that means to say, to represent collective unity.
May I just remind you of the time?
Oh, Christ, how are we doing?
It's now been 45 minutes.
Well, okay, I have till midnight, but okay, so what I want to say is that we don't have unity, we don't have plurality, we have unification and pluralization. It's a process. We don't have an identity. We become a group with an identity through representation, and in that very same process, we become different to ourselves. So that means also that democracy has a serious problem. Whoever first says we on behalf of the we, by definition cannot have been authorized to do so, because in that very act you create the we in a certain sense. And so therefore democracy is never only about representation. Democracy is always also the institutionalization of the possibility of resistance to representation. And therefore, precisely the whole point is that the judiciary is not only there with the risk of the tyranny of the judiciary. In a certain sense, the judiciary there is also as a way of a counterpoint to the tyranny of the majority that claims for itself the right to speak on behalf of the whole. That's why we have fundamental rights. That's why in most countries we have constitutional review as a way of precisely keeping separate the idea of the people as a unity and the people plurality. And so I would say that you could actually rewrite Article 50 of the Dutch Constitution. And I said this once in a meeting of the group of Staatsrecht in the Netherlands. And I almost had rotten tomatoes thrown at me, and they were not of the SP, these people. You could rewrite Article 50 by saying de Staten-Generaal, het bestuur, de rechters en het volk als kiesgerechtigden vertegenwoordigen het gehele Nederlandse volk. And it would not be any different to what it already is. And so this means that because you cannot include without excluding, democracy is, I think, a way of institutionalizing the understanding of the fundamental contingency of collectivity. That however we interpret who we are, it could be interpreted otherwise. And that what we call plural subjectivity, in the sense of Margaret Gilbert, is the understanding that democracy has to play both sides of the game, we together and we each. And that therefore there is a form of radical plurality, the stranger in ourselves. I just mentioned the case of the Aboriginals. We now have that clearly in the Netherlands with the Soevereinisten, and in Germany with the Reichsbürger. Or on the other side, with the Rote Armee-Fraktion and the Brigatisti in the years of lead, when Aldo Moro was assassinated in Italy. And so democracy in a certain ways is trying to postpone, even if never being able to ultimately continue postponing, that moment, authoritative, but also authoritarian moment where you say, this is who we are. Now, to get back to, once again now then, to get it into climate litigation. So, in my view, the three branches of power are political representation, so too election and referenda, and my argument would be that, in fact, private lawmaking, I'm thinking of contracts, I'm thinking of testaments. I would say that private law is no less public law than public law. Because in the course of drawing up a contract, you are in fact articulating for that case in particular what counts as common, who we are. And so I would say it's political representation all the way down, including litigation. What you're doing when you're discussing litigation is raising the question in the judiciary, who are we? And who belongs to the we? And so my claim would be that both public and private interest litigation are manifestations of political representation. And so there's an analogy between casting a vote. If you say what you think there should be understood as the common interests, and litigation, even private interest litigation, there you are arguing, if there's a breach of contract, and I take up one of the positions in that breach of contract, I'm arguing that for my case, this is who we are. So there's as much a process of political litigation going on in private interest litigation as in public interest litigation. And that the role of the judiciary is to settle that conflict of representations through what is itself a representational act. And so I'll drop this, but I'll simply want to say, well, no, I don't want to drop this. So if it is the case that we the people involves inclusion and exclusion, I would say that what's typical for modernity is that what we have not contested is the distinction between society and nature. The we can be broader or narrower, but it involves human beings. And what's left outside is nature. And so I would say that what's fascinating for me about climate litigation, it's one of the ways of trying to articulate that process of inclusion, exclusion, that says, hey, we have included the other than human, but by excluding it in the form of its being an object of legal relations between humans who are oriented to realizing human ends. And what, for example, the rights of nature movement tries to do is to shift the other than human from the position of an object of rights and obligations to a subject position. And in that sense, destabilize the society-nature distinction. And so in a way, what I think climate litigation is trying to do is to reconfigure the we of we together, both into the future, that is to say, future human generations, as you saw in the case of Burgenland, but also to include other than human beings. Now, my questions there would be, how transformative can climate litigation be? And I would argue, and I won't go into ecocentrism and Latour, I have just written a paper on these issues. If you're interested in that, I'm happy to circulate it. But I would argue that rights of nature and even Latour's politics of nature cannot avoid in a certain way reintroducing a certain anthropocentrism into our understanding who counts as part of the we. And what I would want to argue also, and this brings me to a critique of a colleague of mine at Queen Mary, who's written this wonderful article, Alexis Alvarez. He says, look, it's not what you can read it. I'm almost finished. Another hour. And so, what worries me, it's not that I'm against rights of nature. I think that they actually do have a role to play. But what I'm worried about is that as long as we think that environmental law and rights of nature are going to be a game changer, I think we're deluding ourselves, and they risk becoming an ideological venture. Why? Here, I'm reminded of Maria Bartel, who perhaps is listening in with us. We had this initial... Hi, Maria. There you are. I can't see you, but happy to have you with us. When we had the opening workshop for the project that I'm still involved in, it's called Constitutionalizing in the Anthropocene, which is part of the sector plan that we have in Tilburg. Maria said very rightly, we have several technology freaks. She said, don't forget the political economy when inquiring into constitutionalism in the Anthropocene. I haven't forgotten your comment then, Maria, and I will not forget it. And I'll be coming back to pick brains again with you guys later on about this, because for me, what is really essential is if private law is public law, then I think where the Anthropocene, where what I would call catastrophic environmental degradation is taking place, is in the basic institutions of private law that underpin the political economy of the present. Rights of nature and environmentalism will have something to do as long as the assumption is that what contract, corporation, property, tort, labor, and consumption are about is furthering human interests as being the ultimate value of collectivity, we're fucked. And so my proposal is, with Maria, don't forget the political economy. And the book I'm writing now is an attempt to think through what it means to speak about a more than human collective, philosophically. And then the next book I want to write will be the book to actually engage one by one with each one of these fundamental institutions of private law to see how that human subject, other than human object, underpins what it's about, and begin to look at where it can be destabilized. And there's a lot going out there in the doctrine in this way. And I'll simply conclude by saying that I've always thought that lawyers are the best philosophers of law around, as long as they're doing law. That is to say, the way that lawyers can engage with philosophical questions, thinking through the foundations of their own discipline, is unparalleled as a feat of imagination. And so what I want to do with this second book is actually engage with lawyers to see how they are trying to subvert the basic presuppositions of private law. Thank you.